To introduce our topic this evening, I think many people commonly assume that UK and US corporate law are similar, and they are similar in certain respects. But many commentators talk about the so-called Anglo-American corporate law system as if it's some sort of single homogeneous system. And as I think we've already illustrated, particularly in the corporate governance and in the US corporate law courses, there are some quite significant differences between the two countries when it comes to corporate law. And those differences are no more paramount than in the case of public company takeover regulation, which is a focus tonight. Certainly when it comes to the regulation of takeovers, especially takeovers involving public company targets, the UK and the US very much diverge, and the differences between the two systems become very, very prevalent. These differences are prevalent academically, as we will certainly have discussed in the US corporate law module. And you won't, those of you doing corporate governance, I'm guessing you won't have covered takeovers yet, but I'm guessing that's next term.
We're not really focused.
So you're not doing it? Oh, yeah. Well, this is even more relevant tonight. But there are quite notable differences in this area between the systems. They're relevant academically, and they're also highly relevant in practice as well, and that will be our focus tonight. And tonight we're going to be looking at the challenges faced by professional legal advisors when advising on these issues, particularly when advising US corporate clients with respect to potentially taking over UK public company targets, where the differences between the two systems really come to the fore. And we'll also be looking at a couple of case studies which illustrate these problems quite pertinently. So I can introduce this evening's speaker now. I'm delighted to introduce Guy Lewin-Smith, who has over 30 years experience in a wide range of mergers and acquisitions, equity capital market and corporate finance advisory matters. Guy has advised clients from a broad range of sectors and industry groups, including financial services, energy, natural resources, mining, food and beverage, infrastructure, private equity, and also sovereign wealth funds. Much of his transactional work has been cross-border and multi-jurisdictional, including between the jurisdictions we're focusing on tonight. He's advised listed companies on a range of compliance and corporate governance issues. He's also acted for companies and financial advisors on public and private M&A, IPOs, other equity capital raisings and joint ventures. Mr. Lewin-Smith joined Debevoise Plimpton as a partner in 2008. Debevoise Plimpton, of course, if I'm right, being a US law firm, although you worked principally from London. Prior to joining Debevoise, Guy was a corporate finance partner at a leading international law firm who, for legal reasons we can't name, but
actually it was Linklaters.
I was going to say it rhymes with Linklaters, but whilst at that firm, his clients included listed companies, investment banks and brokers. He was also responsible for founding and developing the corporate practice in Linklaters Singapore office, which is quite a legacy to leave behind. So we're going to have a discussion, and I'm going to contribute, particularly with regard to elements of US corporate law, with Guy offering his insights and experience, mainly on the UK corporate law front. But I think to begin with, since very few of us actually have a background, ironically, since we're in the UK, very few of us, I'm guessing, actually have a background in UK takeover regulation. So it will be useful to learn some of the idiosyncrasies and the peculiarities of the UK framework, which is very much an outlier in many respects in international terms. So to fill you in that side of things, I'll hand over to Guy to begin tonight.
Thank you very much, Mark, and good evening, everybody. Can you hear me all right? Is this working? Good. As Mark says, I'm keen that we should try and use our time together this evening to be as interesting and helpful to you as possible. But I'm also conscious that this subject is a little bit specialist in the sense that I think even amongst practitioners at leading UK firms or leading US firms, public M&A tends to be a little bit of a marquee practice for the firms. It's clearly the sort of work that a lot of corporate lawyers like to work on because it tends to be high profile. We're talking about transactions where the amounts of money involved can be gigantic. Billion pound transactions are now becoming not uncommon, and some of the deals we're going to look at today are well in excess of $10 billion. So these are probably the giants of corporate finance transactions. So if you're an M&A lawyer, certainly one who's ambitious to work on some of the most challenging and exciting transactions, then public M&A tends to be very popular. That said, what I'm going to try and do first of all is to give you a little bit of an overview of how public takeovers are regulated and conducted in the UK. Now, we could spend hours, if not weeks, going into that in detail, but we only have, I think, 10 minutes. So this is going to be a little bit of a rush. But again, as Marc said, if at any stage what I say appears baffling or makes no sense, or I've fallen into the trap of using jargon, then please stop me and please ask questions. So just starting off, one of the things that makes public takeovers different and I think interesting from a legal point of view is, of course, that they share a number of features which makes them very different from a private M&A transaction. So essentially we're talking about the acquisition of shares in a company. Now, you're all familiar, I'm sure, with acquiring shares in a private company, where, of course, the two parties will negotiate typically a sale agreement. The buyer will expect to get protections for its investment through warranties, indemnities, and other contractual provisions. There may be structures to provide recourse to boost the credit of the seller if the buyer has to make claims. And those negotiated transactions often also involve heavy amounts of due diligence, data rooms, and all the rest of it. I'm sure you're all pretty familiar with a private share acquisition structure. And the way those deals are done in the UK and in the US in substance is pretty similar. However, when we come to public deals, there are, of course, a number of features which make them sort of quite different. And the first one, of course, is that the shares in the target company, of course, are trading on the stock exchange, both before, during, and right during and during the whole offer transaction itself. So that immediately raises, of course, concerns for the regulators that there should not be a false market created in those shares by information leaking out and giving hedge funds or other players in the market the opportunity to effectively inside a deal, or at least deal on a privileged basis, which is why the UK system of regulation places a huge amount of emphasis on confidentiality during the initial phases of a transaction, and then has quite strict rules about what's required from the parties if a leak occurs, and therefore the media or market participants start rumours about a transaction involving particular companies. Secondly, of course, if you're the buyer, if you're the bidder, buying the shares in a public company, of course, is very different, because there could be hundreds, if not thousands, of shareholders in a public company, as you'll be aware. And today, the situation is often even more confusing, because certainly in the UK, it's quite common for beneficial owners to actually sit behind nominees on the register, on the share register of the company, and sometimes you'll see several layers of beneficial ownership behind the legal register. So identifying who are the beneficial owners, or speaking to those, reaching out to those beneficial owners to persuade them to accept your offer, obviously represents a challenge, because you can't contact them individually. So how do you do that? Well, the answer is you use the process of a tender offer to send documents to them and indeed make information available to them in other ways about your offer, with a view to, of course, persuading them to accept the offer. That, of course, raises the question of the need for the information that's provided to the public shareholders to be of very high quality, not to be misleading, and to be sufficient to allow them to make an investment decision. In other words, should I accept this offer or should I not? The other interesting feature of public takeovers is that, of course, if one party announces a bid for a particular listed company, that not infrequently may cause another party or parties to want to bid as well, in which case you end up with what we typically describe as a public auction. So you can quickly see a situation where more than one bidder is bidding for the target company, which obviously raises issues of complexity for the regulator as to how you make sure that those competing bids can effectively be considered by the target shareholders on a sort of level playing field basis. So that obviously has timetable implications, and it has implications for the way that the price which the target shareholders may ultimately accept can be bid up by one party bidding the price up against another. And finally, for the buyer, unlike in a private share transaction, you're not going to get any contractual recourse against the sellers of the shares in the target. There's no share purchase agreement containing warranties or indemnities from the sellers. So the only warranty that you get in the acceptance form on a public offer in the UK is a warranty as to title. So, I own the shares, I'm accepting. So bad news for the buyer, no contractual recourse. However, it's not all that bad, because typically buyers get comfortable in terms of the information that's available about the company they want to buy through the fact that because it's a listed company, it will have loads of information out there about it. And of course, under the UK listing rules, listed companies are required to publish very detailed financial information at least twice a year, and to update the market on material developments in their businesses. So there is in fact a lot of information out there in relation to public companies. So that allows bidders to essentially bridge that information gap. That said, bidders often also want to do some due diligence. And in a public company context, that raises issues of confidentiality and potentially, of course, if leaks occur, issues of insider dealing. So any due diligence process in the early stages of a public transaction has to be very carefully regulated, and target companies may be reluctant to allow anything like the scale of due diligence that you see on private transactions. So, just moving on to the UK regulatory structure. In the UK, takeovers are essentially administered by an organisation called the Takeover Panel. I don't know if any of you have heard of the Takeover Panel? No? Yes? Yes. Sort of, not quite similar roles to SEBI in India, but the Takeover Panel was formed in the 1960s in a very pragmatic way in the City of London, when people who were advising on public transactions realised that they actually needed someone to hold the ring on takeover transactions and to provide a set of rules, both procedural and substantive, by which transactions could be conducted. But they did it in a very, very practitioner-based way. So the Takeover Code is a small booklet. It's a little A5 booklet, probably about 150 pages long, and it contains general principles which parties to takeovers are required to adhere to, and then more detailed rules and practice notes and guidance. But the Takeover Panel itself is an interesting organisation because it's very different from the sort of statutory regulators who govern takeovers in other jurisdictions. And perhaps Mark would like to comment on the difference when we look at how the SEC operates in the US. But the Takeover Panel is very small. It's executive, which is the people who answer questions and run takeover transactions day to day, contains about not more than 20 professionals, of which about half of them are actually people like Bobby. They're people seconded from major law firms or accounting firms or banks who actually spend 2 years at the Takeover Panel advising on, regulating and advising on takeovers. So it's a heavily practitioner-based organisation. As a result, it's quite cheap because even though the Takeover Panel levies fees on transactions, its budget is not significant, and certainly nothing like the sort of budgets you see for the SEC and regulators in other countries. But as a result of being very practitioner-based, the way the panel works, its modus operandi, is to encourage parties to takeovers to consult it. And that just means ring them up and ask them a question. And they're extremely responsive, they're experienced deal doers, they understand issues that can arise. So when you read the takeover code, very frequently a particular rule will have a note to it which says parties who are unsure about whether this particular rule applies should consult the panel. So consulting the panel is a sort of ongoing dialogue between the two parties to a transaction which goes before the transaction becomes public and typically goes on right through to when the transaction closes. And the other good thing about dealing with a takeover panel is that they're very responsive and they can give you answers typically quickly. Even if they have to consult internally, you typically get an answer the following day to your question or your requirement for a particular point to be cleared. People, and because they are practitioners and because the senior people within the takeover panel executive have been regulating takeovers for years, they have a vast pool of experience. So they typically will look to precedent transactions in the past although they won't be necessarily bound by the precedent transaction in the past, but there is a body of obviously know-how and knowledge as to how the code should be applied to a transaction that's been built up since the 60s. So formidably sophisticated, really, compared to perhaps regulators you see in other jurisdictions. Now, in the UK, there are basically two structures that are used for acquiring public companies. One is called an offer or a public offer, and that's basically similar conceptually to the tender offer that I know you've been, those of you on Marc's course have been looking at. So public offer is very much what it sounds like. The bidder makes an offer to the target shareholders, and they choose whether or not to accept it, and provided the bidder obtains sufficient acceptances, and in the UK there's a minimum acceptance level of 50% in order to obtain control, although typically bidders will actually pitch their acceptance level at 90%, and the reason they do that is to take advantage of squeeze-out rules under company law so that they can acquire the minority, assuming they get to 90%. So an offer is fairly, I think, comprehensible by most people. But the other structure that is actually now the dominant structure in terms of being used on nearly all bigger transactions is called a scheme of arrangement, which sounds a bit mysterious, and it is a little bit mysterious, particularly to my former US clients when I tried to explain to them what this is, because they could get what a public offer is, because that's like a tender offer in the US. But a scheme of arrangement is a peculiar UK company law construct, although I think you'll find it in many Commonwealth jurisdictions as well. For example, Australia, India, I think, also has the scheme of arrangement structure in its company law. So under a scheme of arrangement, it's actually the target company who proposes a scheme, which typically is that its shares should be acquired by the bidder, let's say for a cash consideration. So the actual question that the shareholders are asked to vote on is pretty simple. But the Companies Act sets out a procedural structure for how that transaction occurs. Now, the key things that you have to do in order to get a scheme through is to send a circular to the shareholders, convene a shareholder meeting, and get a vote through the shareholders to approve the transaction. And in the UK, that is quite a curious voting requirement, because it's a two-phase test. First of all, you have to get a 75% majority of those voting in favour of the resolution. And secondly, you have to get a majority in number of those shareholders who vote in favour. So rather a curious two-stage test, which again is confusing typically to my former American clients, because it sounds obscure and they don't understand why there should be two elements to it. But once you obtain that majority, you then finally go back to court. This whole process is governed by the court, by the High Court in London. And at a final hearing, the judge, if he's satisfied that the procedural and other requirements have been met, will give an order. And the effect of that order is very profound, because the effect of the order is that 100% of the shares in the target are transferred are ordered to be transferred to the bidder. So essentially, you have no problems of minorities or holdouts if you use a scheme of arrangement. You get 100% control. And obviously that is very attractive to most bidders, which is why the scheme has become very prevalent as a deal structure. The other reason why it used to be favoured was because there used to be a stamp duty, a tax advantage in using a scheme where you cancelled the shares of the target, but the government took that away last year because apparently they like to raise more tax, so they decided anything that saved stamp duty was a bad idea, so that got cancelled last year. But people are still doing schemes, but the scheme now is to transfer the shares from the shareholders to the bidder rather than have the shares cancelled and new shares issued to the bidder. So when you think about public takeovers, who are the key decision makers on a public bid? Well, obviously, front up, the shareholders, isn't it? It's the shareholders of the target that the bidder's really trying to win over, either to get them to accept the offer, if it's an offer structure, or to get them to vote in favour of the scheme, if it's a scheme structure. But actually, there are a number of other stakeholders who clearly come to mind. Now, the first, of course, is the board of the target. And I think we're going to discuss with Marc later on some interesting differences about the role of the board or how boards behave when they're subject to public offers in the UK. In that the UK system is that the board really has very little discretion to try and frustrate or hold up a transaction, and its duties is very much to ensure that the shareholders get a chance to decide on the transaction. Whereas in the US, I think you can see boards being much more determinative in the sense that they may seek to frustrate or prevent or hold up a bid transaction. But there are a whole load of other stakeholders that typically will get involved in a high-profile, large M&A deal. So the employees, the trade unions, clearly may have something to say about the bidder, particularly if it's a foreign bidder, and particularly, of course, if they're concerned that it may lead to job losses. So that's clearly a political issue. So politicians will want to get involved, particularly if the company being taken over is seen to be, a national treasure of one way or another. In other words, a company that people think of as part of the UK's industrial fabric, although most of those have now been taken over by foreign companies. But there is clearly the potential for a lot of media interest in these transactions. Regulators may get involved if the transaction raises antitrust or other regulatory issues. And of course, the local communities in which the company's factories or the company's HQ is, may also get involved. So it's overly simplistic to think that it's only about the shareholders of the target and the board. Actually, nowadays, particularly on big deals, high-profile deals, you can get a whole sort of storm of stakeholders wanting to have their views listened to, which may or may not be of any persuasive effect to the bidder, but that doesn't mean that they're not going to want to have their say. Very briefly, in terms of the key terms of a public offer in the UK, obviously consideration is key. Typically, most transactions nowadays tend to be purely for cash, although, as we'll see in the couple of case studies, often you'll see a mixture of consideration being offered to the target shareholders, whereby the bidder will offer shares, new shares in itself, plus some cash. So you get a proportion of shares and a proportion of cash. Sometimes you have flexibility to choose more cash and more shares, which is called a mix and match option. But those are the two main forms of consideration. Sometimes in the UK you see bond debt obligations being offered, called loan notes, which are done really for UK personal tax reasons, but you don't tend to see them very much on big cross-border deals. Conditions are key. One of the issues for a buyer, of course, or the bidder is, well, what conditions can I attach to my offer which might give me the chance to walk away from the deal if they're not satisfied? And the two key ones in the UK are, firstly, the acceptance condition, which I talked about earlier, minimum of 50%, but typically pitched at 90%, waivable down to 50%. The other one is EU and UK merger reference, if the transaction is referred to the EU for review, or indeed to the CMA in the UK. The effect of that is to suspend the transaction. But in addition to that, you'll typically see several pages of more commercial conditions put into an offer document. But in reality, they are not particularly helpful to the buyer, because the takeover panel takes a very robust view about not allowing bidders to walk away or call deals off on the basis that one of those commercial conditions has been breached, unless it really is, of fundamental significance to the transaction. And the examples of where people have tried to rely on commercial conditions to walk away show that the panel is extremely reluctant to allow that. Why is that? Well, it's because of the panel's desire to make sure that transactions proceed with a high degree of certainty. So from the bidder's side, you've got to realise that if you make a public bid in the UK, if you become bound to make a public bid in the UK, and you get the level of acceptances, you're pretty much required to go through with it. And there's very little wriggle room. There's very little ability to walk away. Probably the only two ways you can really hope to walk away is either if your acceptance condition isn't met. So that's why the 90% is quite helpful sometimes, because to get to 90% clearly is a pretty high level of acceptances. And if you don't get to 90% by day 60, which is the 60th day of the offer period, then you can walk away for that reason. The other one is if you have your own shareholder approval, if you're the bidder and you need your own stockholder approval, that is another, and provided you provide for that up front in your offer, then that's another reason why you can walk away from a transaction. That happened recently in the AbbVie Shah transaction, which was a large transaction last year. Finally, the practitioners talk about transactions as sort of falling into two buckets, both of which I think is pretty self-evident. Firstly, recommended. So a recommended transaction is one that's friendly between the parties. And typically what that leads to is, provided the price is right and the target board is happy that the price is fair, then they'll be asked to recommend the transaction to their shareholders as being fair. In other words, we think it's fair for you to accept the price that's being offered. So getting a recommendation from the target board is the absolute primary aim of any bidder. Now, obviously, that can lead to quite sensitive commercial discussions between the bidder and its advisors and the target and its financial advisors, because bidders typically don't want to overpay. Meanwhile, targets don't want to be seen, the target board doesn't want to be criticised for having sold out or recommended shareholders to sell out at below what is seen as a proper premium. And typically, in order to get a recommendation in the UK market, the bidder has to pitch its offer with a premium of at least 30% to the undisturbed market price. Sometimes, as you'll see, those premiums go higher than that. So if the bidder lowballs its offer, then the target, with its financial advisors alongside, the target board may say that's just not adequate, that's not sufficient, we're not prepared to recommend. And if that's the case, then the bidder has two choices. It can either accept that and walk away, forget the deal, or it can go hostile. Now, hostile is where you make a bid for a company without the recommendation and support of the target. And the two case studies we're going to look at in a minute are both examples of hostile deals where there wasn't an agreement between the two parties as to a price, which would then lead to the transaction proceeding on a recommended basis. In the UK, again, one of the unusual features compared to what happens in other jurisdictions is that takeovers, because of the role of the panel effectively as an arbiter and resolver of disputes between the parties by reference to the rules of the code, there's swift justice in the UK, and there's no need and indeed no right to seek redress in the courts during the course of a takeover offer. The takeover panel has now been put on a statutory basis, which means that the courts will not interfere in its exercise of its decision-making during the course of an offer. So tactical litigation is not a tactic in the UK that's available to bidders or indeed other parties who want to try and interfere in a transaction that's been announced. But the takeover panel is not a toothless body. Because of its statutory powers, it actually has quite a wide range of abilities to put financial or other enforcement sanctions on people who break the takeover code. And it also has a disciplinary role in that if it thinks that parties to an offer have not conducted themselves properly, or if the advisors to either party have not conducted themselves properly and have not discharged their obligations under the code, then they may criticise or censor those parties, and that's regarded amongst the advisory community as a very embarrassing and very shall we say, career-destroying thing to happen to the bankers or lawyers or accountants involved in being sanctioned. I'm pleased to say that lawyers have extremely rarely been publicly censored by the takeover panel, but it did, I'm afraid, happen last year to a large Magic Circle law firm, which I won't mention in this regard. So that's.
Just to clarify, is that censure of the firm, or is it also censure of the individual?
It can be of both. It tends to be the firm, though. Right. Although if the panel has a disciplinary hearing and reviews the conduct of the key bankers, lawyers, or whatever on the transaction, you may find them named individually in those rulings. So there can be personal embarrassment and opprobrium if the individuals are actually named. And actually, of course, the market knows, because their names tend to be disclosed on the offer announcement, who are the key advisors, key individuals at each institution that's involved on a bid.
But is that the reliance kind of defense that the board, is that because the board can take the reliance defense, that is, they relied on the experts?
No, maybe I didn't explain well enough. Under the takeover code, the target board, and indeed nearly always the bidder, are required to have financial advice, required to have an investment bank or broker. Now, the law firms are not required, but they nearly always are there. So typically both sides will have a team of advisors helping them on the transaction. Now, the financial advisor is seen by the takeover panel as responsible for ensuring that its client conducts itself in accordance with the code. So, as we'll see later on in one of the case studies, if the panel finds that one of the parties has breached the code or breached a requirement of the code, then they typically will also investigate the responsibility of the advisor as well. So that is why advisors clearly are very keen to make sure that they advise their clients properly and fully on the implications of what they're proposing to do under the code. But also the advisors have a bit of a policeman role as well as an advisor role, because they can be held to account by the takeover panel if the takeover panel is not satisfied that they've done a good job.
And it extends to legal advisors as well, is what you're saying.
Yeah. So that's a canter through the structure in the UK. Here again is a quick timeline. I'm not going to go into this at all. This is really just to give you a feel roughly for the sort of length of time that these transactions can run. This is an example timetable for an offer. The timetable for a scheme will be similar in duration, maybe a bit shorter. But what this timeline doesn't show is that before announcement, in other words, when the transaction first becomes public, I mean, typically, of course, you can have several weeks, if not months, of prior discussions on a confidential basis between the bidder and the target and their advisors. So provided those discussions can be kept absolutely confidential and no leaks occur, that's fine. But if a leak occurs, the rules require immediate announcement and identification of the parties, and that has implications for the timetable. Roughly speaking, once a binding announcement is made, which under the takeover means an announcement whereby the bidder is required to proceed with the offer. In other words, there's no walking away from the time you make a binding announcement. The bidder has 28 days after that announcement to post its offer document. Then the target shareholders typically have 21 days after that to the first closing of the offer, when the bidder will announce the level of acceptances that it's received. Typically on day 21 they will have very few acceptances, largely because shareholders tend to, of course, sit on their shares till the last minute and right up to day 60, which is the final day in which the bidder can go unconditional as to acceptances, because of course they want to see if someone else is going to come along and offer them a higher price. So, acceptances during the first weeks of a takeover tend to be very low. And the action hots up as weeks go through, as you'll see at other intervals during the process. The bidder will be required to announce the level of acceptances, and then both sides, of course, may, in a hostile situation, you may have new information being released by both sides, trying to persuade the shareholders to accept their point of view, until you get to day 46, which is the last day for the offeror to revise or release new information. And the idea is that for the last 2 weeks, the shareholders should have time to make up their minds without being bombarded with significant additional information. But day 60 is the key day for the bidder. On a recommended transaction, typically the bidder by then will have got well over 50% acceptances and will declare the offer unconditional as to acceptances. And then it has, provided it can get through 90% of acceptances, it can then seek to acquire the minority using the compulsory acquisition powers in the Companies Act. But I'm not going to go into much more detail on that given time. Okay, any questions on any of that? Was that, I'm sorry that was a bit of a sprint through the UK takeover landscape, but was any of that mysterious, mystifying, made no sense, all of the above, all of it?
How much time does the court take to approve a scheme of arrangement?
Okay, schemes of arrangement now have very well trodden timetables, and the process requires initial application to the court by the target company for an order on a summons to get an order to convene the meeting of shareholders, and that is now a very conventional process. So it's a straightforward application to make. Then, of course, the target company will hold the shareholder meeting, and after that it would have to report back to the court with an affidavit, typically sworn by its chairman, as to the results of the vote. Typically, of course, they will have exceeded the 75% majority and exceeded the 50% in number in favour. And provided that's happened, you can then apply to go to a final hearing, a sanction hearing, which typically be about a week or 2 weeks after that on a recommended transaction, depending on availability of court dates. So on a scheme, and then at that final hearing, which is typically with a judge, a High Court judge, will, provided he's happy that the procedural and other requirements of the Companies Act have been fulfilled, will make an order, at which point, once that order is filed, the scheme becomes effective and becomes binding on all the target shareholders in the way that I described earlier. Typically, depending on the time of the year and depending on how luck you have with court dates, I mean, you can get a scheme through in 6 to 8 weeks. That's around the typical timetable.
So 6 months.
Not 6 months. It's not 6 months as in India. No. That sounds fast in India.
Are there any legal remedies against takeover board decisions?
Well, the takeover panel, as I've said, because it's a statutory body that's been recognised for the purpose of the EU takeover directive in the UK as being the supervisory authority, the UK courts will not review decisions of the takeover panel executive during the course of an offer. However, if you're the bidder and you disagree with a ruling you've received from the takeover panel, then there is an appeal procedure. So first of all, you can take your disagreement with a decision of the panel executive. Those are the guys who are making decisions day to day. If you disagree with one of their decisions, you can ask it to be taken to the hearings committee, which is basically a committee within the executive who meet regularly to decide on difficult or controversial issues. And then ultimately after that, you can actually appeal it to what's known as the appeals board of the takeover panel, which is a more formal process. It's chaired typically by a High Court judge and has a lot of experienced practitioners on the panel. So there is there's a well-trodden and robust dispute procedure But that's all within the auspices of the fact that you're disputing a ruling of the panel executive and you follow the disciplinary procedure of the panel. What you can't do is then switch out into the court system and try and get your decision overturned by the courts.
Relatively simple question. Can the panel order divestment?
Well, do you mean of shares, ex post facto, or after an offer closes? A legal takeover? No, I mean, really it's impossible to reverse a transaction once it's closed. I mean, once the consideration's been paid and the shares have been transferred, the panel doesn't have powers to reverse a transaction. But I don't think I can think of any examples of where there's been such a fundamental breach of the code, for example, that's only discovered after the transaction closes, such that the bidder might want to reverse it or walk away.
In terms of association?
Sorry?
When a transaction goes through and it's gone through probably a small cap company, but it is still listed, but however there's issues with association in the parties, so it's gone to an associated party without the shareholders having any proper approval because they're hiding through nominees and beneficial ownership.
Well, I mean, again, bidders, even for AIM companies, I mean, they are required to disclose their identity. So, it's not appropriate. I mean, even if a bidder is using a vehicle company, then the owners who are behind the vehicle have to be disclosed. So in the UK, it's not possible for a mystery bidder, for example, to go all the way through a transaction to closure without being properly identified. And the other check and balance on that is that no reputable financial advisor or law firm would work with a client who was trying to do that. Right, okay, well, we're going to try and turn up the voltage here because we're going to look at a couple of very high profile, very contested transactions, both examples of hostile bids. As I said, these are the exceptions rather than the rule. So the number of transactions that are hostile every year tends to be a handful. I mean, the vast majority of transactions are negotiated and then recommended in the way that I described earlier. But sometimes, particularly on cross-border deals, you do find transactions going hostile where in our case, UK targets have resisted the overtures of large US bidders. And the first one we're just going to look at quickly is Kraft's bid for Cadbury in 2009-10, which was extremely high profile in the UK. It had all those ingredients. Obviously, I don't mean just food ingredients. I mean the transaction touched a lot of the raw nerves that I mentioned earlier in terms of getting a lot of publicity and attention from the media, as well as politicians, unions, etc., etc. But the background to the transaction was that Kraft, I'm sure you've all heard of it. At that time, it was a large US conglomerate which owned a whole suite of food and confectionery brands, and Irene Rosenfeld, the CEO of Kraft, was keen to rebalance the portfolio by acquiring a major confectionery company. And Cadbury, those of you who may or may not have heard of Cadbury, it was probably one of Britain's most iconic chocolate manufacturers, but also, as well as chocolate, had a number of other confectionery brands as well. Cadbury at the time had just gone through a demerger whereby prior to 2008, in other words about a year before the deal happened, it split off its soft drinks business. So the company used to be called Cadbury Schweppes. You may have heard of Schweppes, tonic water, etc. So the soft drinks business was hived off, leaving Cadbury as really a pure chocolate/confectionery business. And they were going through a strategic review, trying to increase profitability, trying to make a number of acquisitions of other confectionery and chewing gum brands to try and bolster their share price, which had been languishing. UK funds, in particular pension funds and investors, had been quite sceptical about Cadbury's business plan, and as a result, as we'll see, this turned out to be pretty critical. The share ownership of Cadbury at the time that Kraft made its approach was quite unusual, because nearly 50% of the shares were actually held by US funds and investors, even though it's a UK incorporated and UK domiciled company. But obviously it's an international company. But so 50% of the shares are held in the US. Only about 28% of shares were held by UK institutions, which again is not usual. And at the time of the bid, about 5% were held by hedge funds and other short-term investors, but their role tends to be critical in transactions, particularly hostile ones, because as you may have read in the press, what often happens, particularly where transactions are rumoured, is that hedge funds and other short-term traders will look to buy shares in the market in the target company, hoping, of course, that a bid will come, and even better, a counter bid will then come, so that the price will be bid up, and they can then exit, having taken a nice turn on the transaction. Kraft approached, Irene Rosenfeld approached the Cadbury board. She made an initial offer that was worth around £707.55, a mixture of new Kraft shares and cash, 70% shares, 30% cash. That got very little excitement from the Cadbury board. The Cadbury board was led by a chairman called Roger Carr, an experienced chairman. He knew about takeovers. He'd been through a number before, so he was an experienced and capable chairman. And anyway, he was quick to reject this initial proposal by Kraft. He said it was an unappealing prospect, were the words he used, and he didn't think that it was in Cadbury's interest to be incorporated into a low-growth conglomerate, which is how he described Kraft, which was fairly rude. So after that, Warren Buffett, who's a major shareholder in Kraft, you've all heard of Warren Buffett, he fired a bit of a shot across the bows of Kraft by saying, you really shouldn't overpay here, and I don't want you using too many new shares because you're going to dilute me as an existing shareholder. So he warned Irene Rosenfeld not to overpay for Cadbury. Now, Cadbury, having been in discussions for some time, decided that it had enough of the uncertainty, so they went to the takeover panel and asked the panel to impose what's called a put up or shut up period on the transaction. Now, at that time, the target company, if they wanted to put some sort of deadline on the decision of the bidder whether they're going to make a bid or not, you had to go to the panel and ask the panel to impose a date. So the panel, in this case, imposed a date about 5 weeks later, so that expired in early November of 2009. And meanwhile, obviously the war of words goes on in the media, there's a lot of churning in the share register of Cadbury as the hedge funds and short-term investors start buying in, as they get more and more comfortable that the transaction is going to happen and they can make a nice turn on the transaction. Both sides announced, Kraft actually had to put out some interim announcements about its trading performance, which were not that exciting. As a result, ironically, the value of its bid actually went down rather than went up because its share price went down, so the share component of its offer was worth less. So it was no longer worth £7.55. By the time they actually formally made a bid, it was worth £7.17. So you'd think that's not particularly attractive. But because Cadbury clearly were not going to accept the offer, Kraft essentially launched what was a hostile bid because they didn't have the support of Cadbury's board. And in doing that, essentially what Kraft was doing was sort of saying, well, look, we're getting nowhere with the board of Cadbury, so we're going to make our offer effectively straight to the shareholders. So Kraft executives came over to London, they started to meet with the shareholders, try and get them on side. So, if you think of the position of the board of Cadbury, they're essentially being bypassed in the transaction, which clearly is not something they'd be very happy with. And of course, there's a huge amount of media discussion about the merits of this transaction. because Cadbury was such a famous and well-known brand in the UK. So after having launched its offer, the other thing that the hedge funds and short-term investors were hoping is that someone else would come along and make a bid for Cadbury, and an auction would get going, raising the price. And indeed, there was a lot of speculation that Hershey, another well-known US chocolate brand, and Ferrero Rocher from Italy might get together and bid for Cadbury themselves. And indeed, I think Cadbury's board wouldn't have been too unhappy about that, because Roger Carr, the chairman, sort of indicated that, you know, if they were going to be taken over, he'd pretty much want to be taken over by pretty much any chocolate company in the world apart from Kraft. So there was not a lot of love between Cadbury and Kraft. Now, this speculation that Hershey and Ferrero might make a counterbid pushed the Cadbury share price up to £8.19, so well above the value of Kraft's offer, which you may think means that Kraft has got next to no chance of being successful. But as time went on, the Kraft issued its offer document and started the 60-day timetable that I showed you earlier. Cadbury issues a defence document where it rubbishes all the statements by Kraft as to why it's a good transaction for the shareholders. And then in the last 14 days of the period, Kraft did what bidders nearly always have to do in a hostile transaction, which is, of course, increase its offer, because clearly at that point they had next to no acceptances. So they put more cash into the transaction, because one of the criticisms that the Cadbury board had was that, you know, there was only 30% cash in the offer, and the rest of it was Kraft shares, and Kraft shares clearly were volatile, and therefore they were seeking more of a cash component. It's a more reliable form of consideration. And then, however, the Cadbury board was still not impressed with the revised offer that was, which involved 60p more cash per share, and so they continued to resist Kraft's offer. And so it was only right at the end of the transaction that Kraft was forced to come back with an even higher offer, and this time they took their offer to a hugely higher level. So the final Kraft offer came at £8.40 per share, so plus a 10p special dividend declared by Cadbury, so essentially worth £8.50 per share to the Cadbury shareholders. And at that point, Roger Carr and the Cadbury board said, fair enough, you know, you've more than hit the target that we had in mind. So Kraft was successful at the end of the day. They took over, they closed the offer. Cadbury was delisted and became part of Kraft. But interestingly, 2 years later, it became more apparent to investors as to why Kraft had really wanted to take over Cadbury, because Kraft 2 years later actually split itself into two component companies, one being a food brands company and one being confectionery and snacks, of which Cadbury was a big component. And because of having acquired Cadbury, it allowed Kraft to actually float off two viable large businesses on the US stock market, both roughly 20 billion market cap, each of them. So it now became rather obvious in retrospect as to why Kraft had really wanted to acquire Cadbury. It hadn't been so much for its individual merits, it was much more because strategically they were looking to bulk up their confectionery side of their business in order to ultimately split themselves and create more shareholder value from doing that. Okay, so that's one hostile transaction. This is the sort of media coverage you get on a hostile transaction. The communities in the Kraft's main factories were up in Birmingham in the UK and Bourneville. They also had an important factory in Bristol in Somerdale, which we'll come back to. And the unions were very unhappy about potential job losses as a result of the transaction. Politicians got involved. One of the government ministers made a number of statements about wanting to make sure that Kraft respected Cadbury and its workforce, but the government didn't actually do anything tangible to prevent the transaction going through. So the next one, an even bigger deal in 2015 was Pfizer, the American drugs company, approaching AstraZeneca, one of the two major UK-based pharmaceutical companies. And the interesting thing about this deal is that actually Pfizer never made a formal bid. Remember I mentioned earlier that there is a point of no return where you make a formal announcement of your bid, at which point you're bound to proceed with it and you can't walk away. But what Pfizer chose to do tactically was to approach the AstraZeneca board with a view to a transaction. And indeed, once the news of the transaction got into the public domain, they were forced to make an announcement so the market knew what was going on. And indeed, as we'll see, essentially they tried to improve their price with a view to getting a recommendation 4 times over a few weeks, but ultimately failed to get AstraZeneca's board to recommend, at which point Pfizer decided not to proceed and they walked away. So this actually never was a bid. It was a phony war, if you like, but it had many of the features of a hostile transaction, even though it never became a real transaction. Again, this transaction had a lot of media attention in the UK because it was held up as being another example of a large, nasty American predator coming over and trying to steal one of the UK's last remaining world-class companies on the cheap. So politicians on both sides, including both the Labour Party here and the Conservative Party here, were put under a lot of pressure about whether or not they were going to allow this transaction to happen. Now, it had particular sensitivity because the life sciences business, the pharmaceutical business in the UK, is one of our leading industry sectors, and AstraZeneca, even though it had had quite a checkered history in terms of its financial performance, was seen as a huge part of the UK research base. So thousands of research jobs in the UK potentially on the line. In fact, AstraZeneca, some of you may know, is building a $300 million new headquarters about a mile from where we are here today. It's actually moving its headquarters and 2,000 researchers to Cambridge, which is quite a coup for Cambridge and actually reflects Cambridge's growing significance in life sciences. But Pfizer, actually, as well as seeing AstraZeneca as a leading pharmaceutical company with a lot of potentially interesting drugs in the pipeline, including a number of interesting cancer drugs, Pfizer had another reason for wanting to acquire a UK headquartered company, and that goes down to tax. Now, tax isn't often a huge issue on takeovers, but in this takeover and in a number of others recently, American companies have been seeking to do what's called an inversion transaction. Have you heard the phrase tax inversion? Anybody heard that? Yeah. Basically, the problem for American companies like Pfizer is that it obviously has lots of businesses and subsidiaries around the world, and the trouble is that comparative tax rates between the US and other jurisdictions are actually quite different. The US actually has one of the highest corporation tax rates in the world. I think it's about 37% at the moment, whereas in the UK today it's 20%. So a huge difference. And because of that, Pfizer and other big American companies had been unable to remit profits from a lot of their subsidiaries around the world back to the US because they didn't want to be taxed at 37% on all that additional income. So the idea of a tax inversion, very briefly, is that the American company would essentially look to acquire a non-US company in a tax-friendly jurisdiction, so that could be the UK. A number of others look to Ireland. Ireland has a very low corporation tax rate too. So the idea is you effectively move your headquarters and you move your holding company to the low tax jurisdiction, and then you can then remit profits from all around the world to that jurisdiction and then only pay the 37% rate on your US profits. So essentially you lower your overall tax rate significantly. And in this case, people thought it could have worked to lower Pfizer's overall tax rate by $1 to $2 billion a year. I mean, a phenomenally large potential tax break on this transaction. But that motivation for doing the transaction, of course, was well known in the market and picked up by the media and criticised by a lot of politicians and certainly analysts, because typically on a takeover, you typically want the target shareholders, to be persuaded that there are good commercial reasons for the transaction, although typically what target shareholders are most interested in is what they're going to be paid for their shares. So, the price has to be right, otherwise people are not going to sell. But when you come to trying to persuade the target board to recommend a transaction, they need to see commercial logic to the deal. They need to see synergies, cost savings. They need to see a way that the combined group could be stronger together rather than a mismatch. And particularly because there was this overwhelming suspicion that a large part of the reason that Pfizer wanted to do the deal was simply to do the tax inversion and gain essentially a tax arbitrage. That there wasn't a very compelling strategic reason for Pfizer to acquire AstraZeneca. And related to that was that Pfizer had a track record of having done other acquisitions, big acquisitions in the US, where they were notorious for having, taken the knife to the workforce of the target company they acquired, lots of redundancies and loss of, research and senior jobs at the companies they'd acquired. So clearly AstraZeneca were extremely worried that the same thing would have happened to them if they'd been acquired by Pfizer. Just briefly, because I know we're moving on in time, this transaction, as I said, what happened in this deal was that Pfizer essentially engaged in discussions with the AstraZeneca board and tried to raise its offer 4 times to get a recommendation. And the final one, which they expressed to be final, still fell short of the price that the AstraZeneca board felt they could recommend. And even though that was actually a price that was more than 40% above what AstraZeneca had been trading at before the transaction started. But in doing that, they had a lot of support from some of their shareholders who, supported the board in not selling out too cheap. They believed management about the fact that AstraZeneca had a lot of promising drugs in its development phase that would lead to big profits in the future. And there was a lot of skepticism about Pfizer's motivation, as I say, because of this reliance on the tax inversion as being a lot of the reason why they were doing the deal, not good commercial logic. So I think that's all I want to say about that deal. As I say, that never was a real deal. It was a phony war, but it again showed a lot of the features that we discussed earlier. Politicians getting involved on both sides of the political spectrum, trade unions, analysts, the media, all sorts of people voicing concern about the transaction and trying to influence it, even though actually they don't really have a decision-making role in the deal. The parties who really decide takeovers, as you know, are the shareholders, and the board of the target has a key role in whether or not to recommend them to accept the transaction. Right. I think what we're going to move on to now, Mark and I, is to just look at a few areas of interest on takeover transactions where the approach in the US is really very different from what we have here in the UK. So we're going to try and do a Laurel and Hardy or Jekyll and Hyde or Batman or Robin. You have to decide which one I am and which one Mark is. I'll leave that to you. And we'll do a little bit of a double act here, I hope. Mark will give you a view on these issues from a US side, and I'll give you the UK perspective. And if you've got questions or have got points to make, let's chat about it. But the first one is what's called deal protection, which is clearly an issue of great interest to bidders, because if a bidder thinks they've negotiated a commercial price with the target board and got a recommendation, they really, at that point, want the deal to happen, don't they? They don't want things to happen that could derail the transaction. They want to try and stop the target board, talking to other people that might lead to a counter bid. And they really want the deal to go through quickly and efficiently. So typically, that'll raise the question about a merger agreement or similar contractual arrangements to try and lock that deal down, to get it done quickly so that you get to going unconditional and completing the deal as quickly as possible. Mark?
Well, to explain the US position on this, I think it's useful to bear in mind a general point which we'll discuss in more detail in a few minutes' time, which is that broadly speaking in US target companies, and I should have a slight disclaimer when I use the term US, because as Varsha and Annabelle will know, US corporate law there is no such thing as US corporate law as such. US corporate law principally comes from state law, and there are 51 different state systems of corporate law in the US. The reason there's 51 and only 50 states is because the District of Columbia, where Washington is, has its own state system of corporate law, which works independently from federal law. So we have 51 state systems of corporate law, and how boards of directors of a target company behave in the face of a takeover is dealt with predominantly at state level. Federal law, which comes from Washington DC and applies across the country as a whole, mainly relates to procedural aspects of the takeover. Issues that would largely be dealt with by the Takeover Code in the UK would be dealt with federally, at least insofar as procedure is concerned. But when it comes to how boards of directors act, what they can do and what they cannot do when their company is faced with a bid from a potential acquirer, it's really state law that deals with it. And given that the majority of larger public companies in the US are incorporated in Delaware, they're subject to Delaware state law. So that's why we tend to talk about Delaware law when we talk about US law, at least in respect of public companies. Now, with respect to this issue, which Guy alluded to, where you have agreed a commercial deal, can you lock in the target with a merger agreement or a similar deal protection provision? One general observation to make is US public company boards, when faced with a takeover offer, do not have to lie down. When push comes to shove, they are allowed to defend the bid. They are allowed, within fairly liberal bounds, they are allowed to stand in the way of the bid and actually stop the bidder going to the shareholders. So like in the Kraft Cadbury scenario, where the bidder is faced with a rather stubborn board, they may be stubborn for good reason because they think it's a lowball bid. If the bidder tries to go straight to the shareholders to make the hostile bid over the target company board's head, the target company board are actually allowed to stand up and to stand in the way of the bid, and they are allowed to defend the bid, which means, by virtue of this fact, US company boards have reasonably wide leeway when it comes to locking in what they see as a preferred deal. So if there is a particular bidder that the board wishes to work with, they want to lock that deal in, then they do have, in principle, they are allowed to have deal protection provisions. So-called no-shop agreements are fairly common, where the board of the target company in effect binds itself not to deal with other bidders beside the preferred bidder. And no-shop agreements are frequently coupled with cancellation fees, or break fees as they're sometimes called, whereby the target company in effect binds itself to compensate a bidder for their sunk costs that they've invested in the event that they choose to deal with another bidder. And break fees can typically be enormous. We could be talking about multi-million-dollar fees which target companies will agree to pay. Now, it's not a carte blanche that the board of the target company have. There are restrictions. In particular, the board of a target company that wishes to deal with a preferred bidder will have to undertake something called a market test. So in a US public company, the target company will have to, their board will have to, basically, if there's a preferred bidder they want to deal with, they will have to, not necessarily invite other bids, they don't have to actively solicit other bids, but they will have to leave a certain period of time after the initial bid is announced in order for other potential bidders to enter the fray. If after a reasonable period of time, we could be talking about we're talking about a matter of weeks here, not months. If after a reasonable period of time there are no other bidders who have entered into the fray, then and only then would the target company board be in a position to confidently lock in the bid on the basis that they can then claim that they would actually lose that bidder if they did not do so. The other major restriction on a US target company board's capacity to lock in a bid would be something called the Revlon doctrine, which principally kicks in a scenario where you have a bidding war for the company. And not just a bidding war, but also a bidding war which will inevitably lead to the breakup of the target company. This normally occurs in situations where you have private equity bidders who are typically, in effect, heavily leveraging their bid, so they're making extensive recourse to debt finance in anticipation that they'll be able to use the assets or cash flows of the target company as leverage to basically pay back the lender if and when the bid is executed. So where you have a bidding war, you have two or more bidders for the company who are bidding up the bid price, who are taking extensive recourse to debt finance in the knowledge that it's the company's assets that are going to be used as collateral at the end of the day to finance the bid. In that situation, the company is going to get broken up. That's an inevitable consequence of the bid. In that scenario, the board cannot stand in the way of the auction. They must let the auction take its course, because in a Revlon situation, one and only one thing matters, and that's getting optimal value for shareholders in the auction. So with the exception of Revlon scenarios, and also with the exception of the fact that the board must undertake a market test before locking in a bid, they can lock in the bid with the preferred bidder. They do have reasonably broad leeway to do that, and it'll be interesting to see how the UK situation compares for a British target company.
Well, it's absolutely the opposite in the UK. So, and actually, the provisions of the Takeover Code, which now prevent the parties entering into the sort of merger agreement that Marc's explained is frequently seen in the US, have been significantly toughened up, partly as a result of the Kraft Cadbury transaction that I was talking about earlier, in that at that period, after the Cadbury deal went through, a lot of commentators were saying that the playing field on which particularly hostile transactions were being conducted had actually got skewed in favour of bidders, and that there were a number of things going on in transactions which made the target board, put the target board at a disadvantage in terms of being able to continue to represent the interests of their shareholders and push, for the highest possible price once, the company is effectively in play, or indeed to resist an offer once they've been approached. And even before the Takeover Code was toughened up in this regard, and I'll come to that in a minute, in the UK there are company law reasons which will circumscribe the behaviour of a UK company board. Obviously, directors owe statutory duties, including the obligation to act so as to promote the success of the company, which is a broad obligation, obviously, to act in what they see as being in the best interests of shareholders and related stakeholders. The other thing is that in relation to paying break fees, which, as I will come on to say, have now been outlawed in the UK, but they used to be permitted, although only permitted up to an amount of 1% of the price of the value of the transaction. In the US, you see break fees at 4, 5, even 6%. I mean, astronomical amounts, which therefore, of course, makes the break fee, really quite penal in terms of, the consequences for the target if they break that provision. But anyway, in the UK, it used to be permitted under the code for a target to pay a break fee of up to 1%. And the other reason why it was limited to 1% for company law reasons is that the doctrine of financial assistance under the Companies Act makes it unlawful for a company to pay amounts to assist the purchase of its shares, subject to certain exceptions and exclusions. And practitioners felt that a break fee of up to 1% was probably within the range of what was acceptable without falling foul of financial assistance concerns. And so that was another reason why in the UK break fees never got to anything like the level we see in the US.
There is no financial assistance rule in the US, so that's not a problem.
Anyway, so the post the Kraft Cadbury transaction, the takeover panel did what it often does, and this again I think shows it to be a very responsive and practitioner-based regulator, because what it did is it decided to have a review of the way the rules were operating to see whether or not bidders really were at a tactical advantage and whether or not they needed to change the rules to sort of level things up. And they published a consultation paper, which is the way they typically get comments from the market and from practitioners about whether rule changes should be made. And then they invited comments, and then they published new rules. And they actually made some important changes to the way bids were operating. So firstly, they were worried about virtual bids, which is where companies effectively get put into play without the bidder identifying itself, and rumours going around the market and share prices moving and people buying and selling the shares based on rumours of takeovers. So they've toughened up the rules about when the parties need to identify themselves in public. They then imposed a compulsory 28-day period from the point of time that a bidder is publicly named. It has 28 days to decide whether or not to make a formal offer or not, although that can be extended. So that effectively puts a tight period on the bidder to decide whether or not it's going to proceed. So that's meant to help the target board not being put under siege for months and months, and its business being destabilised by the constant question about whether or not it's going to be taken over. They then also moved to really crack down on merger agreements that in the UK were becoming more and more similar to the US style agreements. So they banned target companies paying break fees at all. So not even 1%, 0. They then also banned what are called offer-related agreements. So that was really a broader category of contractual provisions that again you see in the US that were designed to sort of essentially restrict the freedom of the target board, during the transaction. There are a number of other rules which also circumscribe what can be done. You can't have in the UK what are called a special deal with one shareholder that's not made available to all shareholders. So, for example, you can't agree to pay one large shareholder a different price that you're offering to all shareholders. You have to treat everybody equally. Management can't be effectively bribed or suborned. So incentives or agreements with the target management are scrutinised. You can only essentially offer them incentives which are opined upon by the financial advisor as being reasonable. And a lot of those really limit you down to things like offering them rollovers to their share incentives or other existing benefits that they have. So you can't effectively pick off management and offer them big cash incentives to get them to support your transaction. And even directors can't. One of the things you commonly do just before you announce a transaction is to try and get major shareholders, including the directors, to give what's known as an irrevocable acceptance, which is an acceptance of the offer up front. Obviously, that allows the bidder to say, look, I've got 20% support for my transaction up front, so that's a nice thing for the bidder to be able to say. In the UK now, those acceptance agreements now have to be very straightforward. You can't slip other provisions into the acceptance, the irrevocable acceptance, that effectively restrict the discretion and flexibility of the directors to continue to consider other bids if other bids, for example, materialise. So probably about the only really significant thing you can do to protect your deal in the UK is stake building, which is what it sounds like. That's building a stake in the target company so that you give yourself some protection if the transaction doesn't go ahead, because hopefully if the share price goes up, you can sell those shares, or if a counter bid comes in, you can sell those shares to the successful counter bidder. Although state building has all sorts of issues around it, such that particularly on schemes of arrangement, it's not actually tactically very advantageous to buy shares because you can't vote them on the scheme in the way that I explained earlier. So it doesn't really help you as a bidder to buy shares just to get extra votes. So UK climate extremely now restrictive about deal protection. So the next issue we thought we'd talk about is going forward with this theme of target boards, wishing to do things to, shall we say, frustrate or put off a particular bidder that they might not like for whatever reasons, what can bidders do to put target boards under pressure? Can they use litigation against the directors? Are there other things that they can do to make the target board life uncomfortable?
Yeah, to go back to what I said earlier, the short answer is in the US, boards can do a lot. They can do quite a lot to forestall or frustrate a bid, which they don't think is in the interest of the company. Guy will talk about the UK position at the moment, which is quite different. But in the US, as I said, boards are allowed to stand in the way of a bid to a very large extent, and to prevent the bidder putting their bid to shareholders in a hostile situation. And they can use an armoury of really quite coercive defensive measures to stop the bid in its tracks, or at least to delay it, and potentially encourage a better price from the bidder. The most common, or not necessarily sure it's the most common, but certainly the most talked about, most well known, and also most people would say the most coercive and aggressive form of takeover defence in the US is something which you've probably heard of called a poison pill. Poison pills can take various different forms, but poison pill is a colloquial term for what's more properly known as a shareholder rights plan. And as the US corporate law people here will know, essentially a shareholder rights plan it's a provision typically in a company's constitutional charter or bylaws, which provides that if a particular shareholder reaches a specified shareholding threshold, typically around 15%, once that shareholder, who will be the bidder of course, once that shareholder's holding reaches 15%, the pill will be invoked. And when the pill will be invoked, when the shareholder crosses that threshold, what that means is all other shareholders in the company will have the opportunity to subscribe for new shares at a heavily discounted price, which will typically be a tiny fraction of the company's current market price. The result, of course, is quite readily foreseeable. It means that the company's shareholder franchise will be heavily diluted. The person who's trying to control the company will have their relative holding, really quite radically and artificially reduced, and it will in effect stop the takeover dead in its tracks. Now in public companies, the unwritten implication is that poison pills are never used, and the analogy we use in the US corporate law class is to say they're rather like nuclear weapons in a war scenario. Nobody wants to use a nuclear weapon. Potentially the person using it could be as badly damaged as the person whom it's used against, or the country whom it's used against. But the very fact you've got this weapon in your arsenal can give you a lot of bargaining power. So what poison pills do is, though they're never intended to be used, they give target company boards considerable bargaining clout when it comes to dealing with bidders.
Can I just ask
yeah,
a
sure.
question there? Isn't there preemptive rights available for shareholders?
There's no preemptive, that's a good question, there's no preemption rights doctrine in US law, which Guy might touch on. Essentially preemption rights which apply in Europe, and in particular the UK, denote that when you issue new shares in a company, you must give all shareholders the equal opportunity to subscribe for those shares in equal proportions for a 14-day window. There is no similar provision in the US, which is why poison pills can be used. Poison pills are regulated principally by directors' duties. They're regulated by a doctrine known as the Unicode test. which again the corporate lawyers, the US corporate lawyers will be familiar with. Essentially, Unicol denotes that a board may use a poison pill or any other sort of coercive defensive tactic where a two-stage test is satisfied. First of all, the board of the target company must perceive a threat to the company's business. Secondly, their defensive response must be a proportionate response to that threat. Now, what constitutes a threat to the company's business? Initially, back in the 80s, the courts adopted a reasonably narrow interpretation of what a threat could be. It was initially construed only as a threat to shareholder wealth or shareholder value, and a threat situation was only thought to arise in the case of what's known as a coercive bid, where the bidder's effectively trying to constrain the shareholder's choice to force them into accepting an offer. Now, in the intervening 2 or 3 decades, the definition of what constitutes a threat has been broadened quite considerably. So in a case in 1990, Paramount Time, the Delaware Supreme Court held that where a bid undervalues the long-term potential of a company's business through a strategic synergy with a friendly bidder, in this case Paramount were bidding for Time. Time wanted to enter into a synergistic agreement with Warner Brothers, but Paramount were offering a lot more money to Time shareholders than Warner were. Now, in a UK scenario, eventually Time's board would have had to have bowed down and allowed Paramount to put their superior price to the company's shareholders. Because we were dealing with Delaware law, in effect, Time, the target company, were allowed to employ takeover defences to prevent Paramount getting to their shareholders. That therefore enabled Time to enter into a responsive merger with Warner, which was the friendly bidder, and in effect lock up a preferred bid, which therefore prevented the Paramount bid from happening. Now, of course, as Guy's explained, in the UK that could never happen because eventually Time's board would have to have bowed down and allowed Paramount's bid to proceed. If Time shareholders were happy with the price Paramount were putting, the deal would have gone through, but they were allowed to actively defend the bid in this case. Why were they allowed to defend the bid? Because Unicol was satisfied. One, they perceived a threat to Time's business. They thought that Paramount's offer posed a threat to Time's business. Why? Because Time had a long-term plan in place with Warner that its board believed would generate a lot more value for its shareholders in the long term, which therefore justified them in not allowing the shareholders to consider Paramount's superior offer, which was superior, they believed, only in the short term, not in the long term. And also, the Delaware court believed that Time's response in defending the bid was a proportionate one. And in even more recent cases, such as for SATA and Airgas a few years ago, the Delaware courts now quite broadly say if the board think a bid that's put for a target company is lowball, to use the phrase Guy used earlier, if it's a lowball bid that doesn't value the company sufficiently in the board's opinion, the board are allowed to defend the bid through poison pills or other roadblock restrictive strategies. So really quite radically different from the UK position. Other points to note, in 33 states in the United States, there's something called the non-shareholder constituency statute in place, which basically provides, they all take their own different forms, but they basically provide that a board of a target company, when faced with a hostile bid, can take into account not just the interests of shareholders, but the interests of any other relevant non-shareholder constituency, including workers, suppliers, customers, local communities. Some of the more radical non-shareholder constituency statutes even provide that target company boards can take into account the state and the nation. Pennsylvania, I think, includes the nation, the United States as a whole, which is a pretty broad stakeholder constituency. The purpose of these statutes is basically they give excuses to a board. The board can roll out any old excuse and say it was considering that interest and therefore decided not to accept the higher bid. Now, notably, Delaware does not have a non-shareholder constituency statute, which is why we don't discuss it in our course. But many states do, which is another factor to take into account. And there's also the potential for tactical litigation as well, particularly in alleged antitrust grounds. under particularly under Sherman Act provisions, which could potentially tie up a bid. It might not forestall a bid, but it can certainly delay a bid. And of course, in a market-sensitive situation, delaying a bid through litigation can be tantamount to forestalling the bid if market conditions change and the bid no longer becomes feasible. So in short, boards can't actively defend bids. But one point to make is, just because a board are defending a bid through poison pills and other coercive measures does not necessarily mean they're acting against shareholders' interests, because takeover defences can, and very often, in fact, usually, I would say, usually are used legitimately for the purpose of pushing up the bid price and encouraging higher bids, potentially even encouraging an auction. So, in some respects, they can actually, they can be overall beneficial to shareholders because the board foresee that shareholders could be enticed into accepting a bid that's too low, and therefore the board are doing shareholders almost a paternalistic service in trying to extract a higher bid through these methods. So, not the same as UK law, though.
Thanks, Mark. So, guess what? It ain't the same over here. I mean, the philosophically, I think the UK company law and the code actually view the role of the board when it's faced with a takeover offer in the UK very differently. I mean, the code makes it very clear that the key constituency on deciding the merits, i.e. the price and the commercial logic of a deal, is the target shareholders. It's not the board. And under company law, again, directors have to be very careful about how they conduct themselves, in terms of directors' duties, if they seek to, pursue a course of action in resisting or trying to frustrate a bid, which isn't, promoting the success of the company for the benefit of all shareholders. Now, the other thing is that in the UK, the culture is such that large shareholders in public companies, actually scrutinise the behaviour of the board and will be extremely upset if they think that the board is behaving in a self-serving way to prevent an offer coming forward that they may like to think about accepting. So the shareholders, particularly the large institutional shareholders, will make their views known if they think that the target is not being open to the possibility of a transaction, and indeed, being prepared to talk to a potential bidder and facilitate due diligence or whatever, because the shareholders at the end of the day feel that if a transaction does come forward, then they should have the chance to decide on it, not the board. And of course, directors can be sacked at the AGM every year if the large shareholders or a majority of shareholders think that they are behaving in a way that is out of line with this philosophy of a clear division between responsibilities, the ownership role being with the shareholders and the management role largely being with the board. But the Takeover Code also bolsters this position, because there's a key rule in the Takeover Code, Rule 16, which prohibits, once a transaction is under discussion or rumoured, from that point on, the target board can't do a whole range of things that might frustrate the making of an offer. So, for example, it can't issue any new shares. It can't enter into disposals or acquisitions. It can't do any of these things without consulting the panel and getting shareholder approval of the target shareholders. So that is a massively and powerful restriction on a board in the UK doing a whole category of things that in the US, as you've just heard, may be open to the board in terms of putting roadblocks in the way of a potential bidder who, for whatever reason, they may not like. In the UK, as I mentioned earlier, there really is pretty much no tactical litigation during the course of takeover offers for the reasons I've explained, namely that the panel is the statutory regulator. The panel deals with issues on a very, very timely basis, and the code has its own appeal mechanism within it if you disagree with a ruling of the panel. And in terms of suing, the target directors individually, really that's very difficult in the UK. Even though under the Companies Act 2006 there is a procedure known as derivative action, where essentially shareholders can essentially adopt the right of the company to sue directors for breach of duty. I've never seen that yet in the context of a public takeover, and indeed I'm not sure that provided the directors act sensibly and take advice, which they're required to do from their investment bank about the price, if they're going to recommend it, and provided they recommend a price that's at least 30% premium to the share price prior to an offer, the chances of there being a successful derivative action against the directors' breach of duty, I think, are pretty much nil. So it's quite different in the UK. So the final one, this is just a few stats, just a few numbers. Well, I'm not going to spend any more time, just to give you a feel of the amount of foreign acquisitions there are of UK companies. And you can see the US, 37% in 2014. In the last couple of years, the US has been prominent. But you can see, acquisitions. This is, by the way, not just public companies. So, the UK has been very open to foreign acquisitions in a way that many countries aren't. I mean, the UK government, and not just the current government, the previous government, successive governments have had a policy of being open for business. In other words, not putting protectionist measures in place or seeking to frustrate transactions where it's a foreign acquirer of a UK company for, if you like, nationalistic reasons or for political reasons. And that, of course, has made the UK very popular with foreign bidders, and as a result of which, we have a very active M&A market in the UK. Foreign companies and from all over the world regularly make transactions in the UK. So the UK is extraordinarily open, really, to foreign acquisitions. Just a couple of other points on protectionism, if you like, or trying to block takeovers at a government level. EU antitrust legislation actually prohibits member states invoking protectionist legislation, save for what is called legitimate interests, which is meant to be a narrow concept of things like defence. But I'm afraid we do see some nations, and why am I mentioning France? I don't know. Some nations tend to take, and Spain, certain countries tend to take a rather liberal view about what are legitimate interests when it comes to blocking what politically they may find to be an unattractive offer. There's a notorious example back in, I think, 2006, where Pepsi of the US was rumoured to be about to make a transaction to buy Danone. Danone, as you may know, is a major French dairy products, cheese, milk, blah, 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 cheese company, yogurts. And the French government managed to persuade itself that Danone was of strategic importance to France and therefore hands off our yogurts. So essentially France even actually passed, and off our cheese, true, they even passed a law which essentially gives the government, absolutely protectionist power to block unwelcome foreign bids, even though that seems to be blatantly in contradiction to the requirements of the EU merger directive. As I said, the UK has been, for good or ill, very open for business. Doesn't even seek reciprocity from the nation from which the bid comes. And as we've seen in Kraft Cadbury, whilst in hostile deals like that, the communities that Marc mentioned, like the employees, the trades unions, the local politicians, suppliers, customers, all these people will have a voice. They do not have, nor does the board have either a common law or a statutory ability to invoke their interests as a reason for essentially frustrating or delaying a transaction where the Takeover Code applies. So the final one, and I'm conscious that we're running on. Do you have enthusiasm for one more? Or yeah, we'll try and get this one done quickly. The final one is just another example of potentially a contentious issue on takeovers, which is that obviously if you're the bidder, in order to try and persuade the target shareholders to accept the bid, you often want to make ambitious claims for why the transaction is going to be financially beneficial. And you may want to give undertakings to the target aimed at its employees and its trade unions to reassure them that there won't be mass redundancies, or they won't move factories or other operational facilities out of the UK. So particularly in a hostile situation, the bidder may well want and indeed need to make categorical statements along those lines. But the question is, what consequences are there if it makes those statements and then breaches them?
Yeah, I mean, I'm not going to say much on this because it's relatively straightforward, but the key disclosure documents that would be required of a bidder in a transaction to acquire a US public company would be a tender offer statement and also something called a 14B filing. And there's a bit of overlap between the two documents, but as part of those disclosures, amongst other things, the bidder will have to disclose the purposes of the transaction and also the offeror's post-bid plans or proposals. What if we have a scenario, rather like the candidate scenario, where the bidder discloses that they're going to do one thing prior to the bid? Once the bid's been successfully executed, you then decide to do something else, such as not keep open that factory that they promised to keep open, close the factory, relocate production. In terms of comeback, in fact, as far as I can see, the options are fairly limited. One potential method of recourse would be under anti-fraud litigation, but really this would only arise in situations where there was clear harm to shareholder value, where there had been a statement that was made as part of pre-bid disclosures about the offeror's intentions, and then that promise was broken. Now, if by virtue of breaking that undertaking, harm was caused to shareholder wealth in some way, perhaps the company's reputational capital was affected, shareholders sold their stock and the company's share price depreciated, we could potentially have a situation where an investor, or more likely a class action attorney, which a scenario we discussed this morning in our class, where a class action attorney purporting to represent a plaintiff group says, well actually what we have here is a misstatement. That was an inaccurate, misleading statement in the pre-offer disclosures, which would be actionable under SEC rules as in effect an aspect of securities fraud. Even though, well, I suppose the offeror does gain from it in a soft way, but even if the offeror does not directly gain from making the misstatement, it would still be actionable under securities law if they knowingly violated the law by knowingly making the misstatement at that point in time. So there is a potential for anti-fraud litigation, but I'd say it's fairly marginal. By and large, the options for comeback in that situation would be limited, and certainly in terms of direct rights of action on the part of affected non-shareholder constituencies, I don't really see a great deal of options there.
Thanks, Mark. So in the UK, again, there is a very, we now have, as a result of, again, some quite recent rule changes, a very strict regime governing statements made by bidders in their offer document or announcements, but even more, a specific regime that governs what are now called post-offer undertakings and also post-offer statements of intention. Now, the cause célèbre that caused this area of the code to be tightened up takes us back to Kraft and Cadbury, where in September, before announcing their offer, Kraft made a statement that they'd be in a position to continue to operate what was called the Somerdale facility. That was a factory employing several hundred workers in Bristol. So they made a statement which they then repeated in their offer document, that they believed that they'd be in a position to continue to operate it. Now, why did they make that statement and why was it significant? Well, it was because it was widely rumoured in the press that Cadbury were planning to close it. And indeed, move production to Poland. And funny enough, they've been building a factory in Poland. Now, right after the transaction closed in February of 2010, Kraft put out an announcement to say that the plans to close the Somerdale facility are now so far advanced that it's unrealistic to reverse them. Oh dear. So you can imagine the media, the unions, the employees, absolute storm broke out about this awful, treacherous US predator, which had given all these reassuring statements about preserving jobs in Somerdale, and was now, within weeks of having seized this national treasure, our premier chocolate company, was now reneging on its commitments and was closing down the factory in Bristol and shifting production to Poland. So, you can imagine that caused a great deal of political and media anger. As a result, the takeover panel agreed to consider tightening up its rules in this area, but actually, as well as tightening up the rules in this area, which they've done, they also actually brought disciplinary proceedings against Kraft and its financial advisor. So you remember I mentioned earlier that if the panel think that either a party to a transaction or its advisors have behaved or breached important provisions of the code, they can actually bring disciplinary proceedings. And actually the panel did that and found that actually Kraft had broken Rule 19.1, which is the rule that says, parties must take extreme care to ensure that all statements that are made in the course of an offer, particularly in their offer documents, are true and accurate, and essentially imposes a prospectus-like level of care on the quality of the documents. And the panel found that actually Kraft had been careless in this regard, because they made that statement while they were still, they were still a hostile bidder, so they had no insight into what Cadbury management were actually really planning to do. And even though it was expressed as a statement of belief, they felt that actually that statement of belief wasn't really made on, reasonable grounds, because they didn't actually have any insight into Cadbury's plans, even though there was a rumour that Somerdale was going to be closed. They didn't actually know exactly what Cadbury management was planning to do, but notwithstanding that, they went ahead and made this assumption or assertion that they would be able to keep that factory open. Now, very shortly after they completed the deal and obviously got access to Cadbury management, Kraft then found out that actually this was way down the track, that there wasn't really an option. There was no real possibility to prevent the closure of Somerdale, because they'd already started shifting equipment to Poland, and actually, therefore, this was a fait accompli. So then Kraft put out this somewhat humiliating announcement where they say that it's now too far advanced and it's unrealistic. But the panel said, that just simply shows that your original statement was just not made with due care. That was an inappropriate expression. It was clearly sensitive. It was made to reassure employees. It was made to reassure the politicians and the community in Somerdale. And actually, you broke the requirement of the code for the quality of those statements to be unimpeachable. And as I said, they disciplined. They found that Kraft had breached the rule. They also criticised Lazards, who are the financial advisors to Kraft, for not having properly policed their client, even though they'd done due diligence, even though they'd verified the statements and their lawyers, Clifford Chance, had verified the statements. Somehow it slipped through the process, and they actually criticised Lazards as well. So there's a good example of the way the panel does actually actively police provisions of the code. Just quickly on the way the panel has tightened up the rules. Now, if you want to make an undertaking about something like keeping a factory open for a certain period of time after the transaction closes, that's now termed a post-offer undertaking. And not only does it have to be given pretty much on an unqualified basis, but also there's now a process whereby you have to appoint an external arbiter to police your compliance with that undertaking for whatever period of time you've committed to do it. So if you say, I'm going to keep a factory open for 2 years, then you have to appoint a supervisor, an accounting firm or someone like that, to police your conduct, and to report to the panel that you are in compliance. So, a hugely toughened up regime. And actually, we've just seen it in action in a transaction, another huge deal this year, which actually also concerns Cambridge. ARM, a company you may have heard of, one of the world's biggest semiconductor companies, has just been acquired by Japanese company SoftBank, a $60 billion transaction, massive deal. And in the course of that deal, SoftBank have given legally binding undertakings to increase employment, to double employment in the UK within 5 years, and to keep their headquarters in Cambridge for 5 years. Now they've appointed Grant Thornton, the accountancy firm, to monitor those statements and their compliance with those statements, and they will be bound by that for 5 years. So, here we are, a new rule brought in and already being brought into practice.
Conclusions.
Conclusions.
So, conclusions with regard to the US system. I think one thing that we probably agree on is that so far as domestic deal outcomes are concerned, so acquisitions of domestic companies in the US and in the UK, we are likely to see broadly similar outcomes. Ultimately, at the end of the day, it's about the price. Whether you have a system in the UK where you have what's sometimes called board neutrality, where the push comes to shove and then it goes hostile, the board have to effectively stand back and let the shareholders decide. Ultimately, it's because the UK takes a general view that shareholders will get the best price under that system. US law is commonly perceived to be a system that favours boards of directors over shareholders. I think, to a large extent, that's actually an oversimplification. I think US corporate law, ultimately, at the end of the day, is about outcomes, and it's about getting the best price for shareholders too. It's just in the US, the general approach is taken that shareholders' interests can be best safeguarded in most cases by having an active, empowered board that can protect them and that can stand in the way of a bid that the board and their superior knowledge deems unsatisfactory. And that encourages conflicts of interest that would not exist in the UK system. The US views those conflicts of interest on the part of the board are a price worth bearing in return for the benefits that type of system offers. And we can have our own subjective views on whether that's an acceptable position. So I think certainly the US takeover law system is indirectly favourable to shareholders, even though in the first place it would appear to favour boards. There's less deal certainty from the point of view of the bidder, the offeror, because it's not clear that the board are simply going to lie down. They may ultimately forestall the bid, or at least delay it to an extent that the bid becomes infeasible, which is always a possibility when dealing with a US target, because of the stronger bid defences. But there is also more freedom on the part of a bidder as well, not to proceed or to walk away, because there isn't really an equivalent of the put up or shut up rule that Guy mentioned, which exists in the UK. We also have more common litigation. There are also, one thing I haven't mentioned is federal protections against foreign takeovers, which are deemed suspicious from a domestic point of view. One interesting piece of federal legislation in this regard is, in particular, it's an important federal body which are legislatively created, called the Committee on Foreign Investment in the United States, or CFIUS, which Guy actually knows more about than me, I would say, having directly worked with them, or at least worked on cases where they've been involved. But CFIUS are effectively a politically appointed body, staffed of representatives from different government agencies, including the Department of Defence, Department of State and the Department of Justice, who are in effect empowered to block deals which pose a threat either to national security or to critical infrastructure. and therefore there is a strongly nationalistic protectionist impetus to US takeover regulation at federal level, which, as Guy's already explained, we don't really see in the UK, which for most intents and purposes is expressly open for business. So that's really a flavour to the US system. I'm going to say something about Trump, but I'll probably wait till you've said something about Brexit before I do that.
No, I'm on Pythias. It's been used to basically strike down a number of potential Chinese acquisitions in the US where there were tangential potential concerns from a defence point of view because they were in the IT sector. But the one that we were personally involved in at Linklaters back in 2005-06 was the notorious case of Dubai Ports taking over P&O, which was an entirely UK governed transaction. But amongst P&O's assets were management contracts over a number of ports in the US. It became, there's a politician called Senator Chuck Schumer, who's a Democrat, who is a guy who likes to get involved whenever there's an opportunity to denigrate foreigners, as far as I can see. And even though, in this case, of course, Dubai Ports is a UAE company, ally of the US in the Gulf War, blah, 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 very close relationships in many ways, he was prepared to essentially voice, national security / terrorism concerns around the fact that, a Dubai entity was going to acquire a UK company that had management agreements over a number of ports on the eastern seaboard. And actually, Dubai Ports was forced to, after the transaction closed, was actually forced to divest of those management those agreements. So there's an example of quite a surprising outcome from a sort of international relations point of view, but just shows that if a politician decides to, or a number of politicians decide to scrutinise a transaction, they can often get traction. So I'm just responding to Mark's comments on the US environment. Again, I think hopefully we've seen that actually the UK approach is very much to the code and the panel see themselves as basically ensuring neutrality in a transaction. They don't want to favour the bidder or the target. They want transactions and the commercial merits to be considered by shareholders. They themselves don't interfere in any way with the commercial merits or commercial arguments around a bid. All they require is that the parties make sure that anything they say about commercial issues or employment issues or whatever are made to a very high standard of care so that investors are not misled. Compared to the US, as I've said, bidders may become obliged to proceed with transactions at a much earlier stage than in the US. And once they're into a transaction, they will have much less scope to walk away by invoking conditions than perhaps you see in the US. We're mercifully, unless you're a litigation lawyer, free of litigation in the context of takeovers. As I've said, the UK government has been and continues to be pretty friendly towards foreign acquisitions and has resisted protectionism or recourse to, shall we say, domestic nationalistic concerns to block foreign bids outside, a number of obvious sectors such as defence. But it's quite interesting in that context, though, to see, to think about what the outcome was on Pfizer-AstraZeneca. AstraZeneca did manage, the board did manage to hold out against 4 successive offers from Pfizer. The UK government did. Pfizer actually ended up writing a letter to David Cameron, the Prime Minister, which was published, in which they made various assertions about protecting UK jobs and things like that. But as commentators pointed out at the time, that wasn't enforceable. That was simply a piece of, should we say, propaganda. So nowadays, if they wanted to make statements like that under the new rules, those would become binding obligations on them. Brexit, what do we think about Brexit? Do we think that's going to change the environment? I mean, to be honest, I don't think Brexit will have a significant impact at all on the way that the takeover code works in the UK and the way the panel operates. There will be some tangential issues around, for example, whether or not EU merger control continues to directly impact, UK targets in the way that it has. So there'll be some fairly minor consequences of Brexit, depending on the degree of Brexit we end up having. But in terms of the general landscape of how deals are done, I think it'll be very much business as usual.
I mean, I'm not so neutral about the US position. I mean, it's a lot of uncertainty at the moment. I think as I've already said, most corporate law, including takeover law in the US, at least the controversial bits of it at state level, I don't see state corporate law, such as, for example, Delaware corporate law, really being materially affected by Trump. I mean, one theme of the Trump approach to government seems to be to cut the federal government and devolve as many issues as possible to individual states. And if that's carried through, we would expect business as usual as far as corporate law is concerned. Perhaps curtailment of securities laws, but I mean that remains to be seen. Where we may see an impact from the Trump presidency in this area is with respect to issues we've just been discussing about economic nationalism and a protectionist agenda. We did see quite notable legislative developments which expanded the federal government's capacity to forestall bids on protectionist or national security grounds. I mean, we did see a broadening of the federal government's scope of powers in this regard, particularly under the Bush administration. So we saw innovations such as the Foreign Investment and National Security Act, the Homeland Security Act and the Patriot Act, which in different ways expanded the definition of critical industries or critical infrastructure, which could potentially form a basis for block and foreign takeovers on national security grounds. Will we see a stiffening up of this approach under the Trump administration? Quite possibly. Also note that the Committee on Foreign Investment in the United States that I just mentioned is a politically staffed body, which does have power to block foreign takeovers. And if we consider, for example, that representatives of the Department of State sit on that committee, it's mooted that the new head of the Department of State could be Rudy Giuliani. Will we see a stiffening up of the protectionist defensive agenda, more national security concerns being brought to the fore within that committee? Quite possibly. So, whilst Brexit, you might think will be neutral for the UK, I'm not so sure the Trump presidency will be a neutral development for the US here. It remains to be seen.
Yeah. Any questions?
Should we withdraw for questions?
Yeah.